So we are going to get started.
Good morning. Thank you for joining us. We will be starting shortly. As a reminder, this webcast is being recorded. You may get a copy of the recording on the DFPI Debt Collection Advisory Committee's public page. At this time, your microphone has been muted and video disabled and will remain so for the duration of this webinar. If you have questions or comments, you may submit them via the chat function in Zoom. During the public comment period, microphones can be unmuted for comments. If you are here in the audience, you may raise your hand. Thank you.
Good morning and welcome to the Debt Collection Advisory Committee meeting. I am Melinda Lee, the Deputy Commissioner of the Debt Collection Licensing Program. I have been with the department for 32 years. I spent my first 25 years of my career in the banking program. Looking to add a new challenge to my career, in 2018, I moved over to student loan servicing to get that program started. And when the opportunity came up to start another program in 2021, I signed on to the debt collection program. I'd like to take a few moments to provide an overview of today's agenda. We will first hear from DFPI's Senior Deputy Commissioner, Suzanne Martindale. This will be followed by a presentation on examination processes. We have allocated 20 minutes for the presentation and to answer any questions from the members of the committee. We will then have a brief legislative update followed by 5 minutes for each of the committee members to discuss topics of their choice. The remaining 10 minutes will be for public comment. Now I would like to introduce those who are in the meeting today. The committee members online are equity partner from Womble Bond Dickinson, Scott Hyman, owner and operator of PNB Capital Group, Sean Welch, CEO of Tavelli, yeah. Thank you, Tavelli Inc., Robert Tavelli, Director of Opportune, Callie Miller, and I think we're missing one member. The members in the room are the Director for the East Bay Community Law Center and UC Berkeley SOL, Desiree Nugent-Orth, and President of States Recovery System, Inc., Cindy Yaklin. DFPI participants online are Debt Collection Financial Institutions Manager Herb Thompson, Assistant Chief Counsel Charlie Career, and Deputy Commissioner for External Affairs Adrian Diaz, and Deputy Commissioner for Legal Colleen Monahan. And DFPI participation in the room is Senior Deputy Commissioner Suzanne Martindale and myself. I will now like to turn the meeting over to Senior Deputy Commissioner Martindale.
All right, thank you, Melinda. Thank you everyone here in the room, and thank you everyone online for joining us this morning. It's a pleasure to be here with you today. My name is Suzanne Martindale, and I'm the Senior Deputy Commissioner for Consumer Financial Protection here at the department. And on a personal note, I'm really amazed at how far we have come here in the last 4 years. I was appointed to this role back in February 2021, when the department was just beginning the process of implementing major legislation, including both the Debt Collection Licensing Act, as well as the California Consumer Financial Protection Law. In my time here, I've seen the Consumer Financial Protection Division grow from a team of 1, it was me, to a team of 51, the lion's share of whom are the debt collector team. So we've come a long way to be sure, but we know that there's much more work to do in the coming years to refine and grow our debt collector program. The work of this committee is a key component of that growth, and we thank you all who have served alongside us. Our team remains committed to the department's mission to protect consumers and foster trust and innovation in the financial services marketplace. And before I turn it over to the debt collector team for program updates, I want to briefly share with you some of our department-wide priorities for the next 2 years. The department recently updated our strategic plan to focus on 5 primary goals that guide our work. Those goals include, number 1, strengthening the financial services ecosystem through oversight and consumer protection. Number 2, driving operational excellence throughout the department. Number 3, expanding DFPI's reach and impact in the public and the community. Number 4, advancing opportunities for Californians to achieve economic security and mobility. And lastly, number 5, elevating our commitment to equity, diversity, inclusion, and accessibility. I understand this will be the last meeting with the current Debt Collection Advisory Committee members you see here today and virtually. I want to thank you all for your service and insights over the last 2, and in some cases 4 years. For those interested in serving on the committee going forward, there is still a little bit of time to submit an application. The department in the last few months has announced via the monthly bulletin and on social media and to all stakeholders via GovDelivery the call for applications. You will find the information on qualifications and how to apply on the DFPI website. And we will also provide a link. Our team will provide a link in the chat in the Zoom. Applications are due on February 28th. That's Friday. So we hope that if you still are interested, you get a chance to apply. The commissioner will be making the selection for the new committee members by April 1st for the start of the next term on April 29th. Our first meeting will be held in May or June in our new location, because we're moving to the Maylee State Office Complex here as we speak. There are moving boxes all around here off Richards Boulevard in Sacramento. And now with that, I'm going to turn back to program. So the next key phase of implementation for our program is related to the startup of examinations. And so with that, and per the request of stakeholders at our last meeting, I am going to turn it over to Financial Institutions Manager Herb Thompson to provide an overview of the examination process. And with that, take it away, Herb.
All right, thank you, Suzanne. Share my screen. All right, so I appreciate the opportunity to kind of present the next phase of our program, which is really focused on examinations. We'll cover some of our program and licensee milestones for calendar year 2025, as well as our examination authority, regulatory framework, and general timeline for examination flow. Additionally, we're going to cover some pain points we've experienced so far and general expectations to responding for a request for an examination. So as most of you are aware, we opened the portal for the annual reports on January 1st of this year. And as of this morning, we received approximately 32% submission rate. Our annual report filing deadline is March 15th. 2025 will be the first year where we will have an assessment, and licensees will receive an invoice through NMLS on September 30th with a due date of January 1st, 2026. As a reminder, NMLS starts their annual renewal on November 1st, which is due by year end. And based on last year's experience, we encourage our licensees to start these processes prior to the required due dates to ensure timely filings and/or payments. However, you're highly encouraged, if you do experience problems, please reach out to us through our inquiry inbox. So examinations. Examinations are a fundamental part of the Debt Collection Licensing Act under Financial Code 100,004A, 100,019 B and D, and 100,023A, and it allows the department to ensure compliance with any laws or regulations under the commissioner's jurisdiction. Moreover, debt collectors are a covered person under the California Consumer Financial Protection Law. Our examinations are billable by law, including travel-related expenses. Examinations are periodic and routine in nature. There doesn't need to be a precipitating event that led to us scheduling a licensee for an examination. However, examinations may result from a specific risk indicator, such as a change in your business activities, a change in your management, merger and acquisition activity, and a change in the size and/or complexity of your business. And that's just a few of them. So that most of our examinations are going to be standalone independent examinations conducted by the department. We will and will continue to conduct joint examinations with other states as well as internal joint examinations for licensees that are duly licensed with other programs. Those programs could include CFL, CRMLA, student loan servicing, to name a few. Again, given the dynamic situation at the federal level, we're taking a wait and see approach with joint examinations with the CFPB. Again, the frequency and scope of our examinations will ramp up over the next several years. So our examination framework. So as a division, we've adopted the FFIEC's Uniform Interagency Consumer Compliance Rating System. That's a mouthful, so we refer to it as the CC rating system for short, to evaluate our licensees' adherence to consumer compliance requirements. It provides a general framework for evaluating compliance assessment factors to assign a consumer compliance rating system or consumer compliance rating based on a scale of 1 through 5 in increasing order of concern. So 1-rated institution would be proactive to ensure compliance, minimize consumer harm, whereas a 5-rated institution shows no consideration towards compliance, and we're likely going to be issuing some sort of enforcement action as a result of an examination. The primary purpose is to ensure that our licensees are evaluated in a comprehensive and consistent manner, and that resources are appropriately focused on areas exhibiting risk of consumer harm and on institutions that warrant elevated attention. So the CC rating system is organized under 3 broad categories, which includes board of management oversight, the compliance program, and violations of law and consumer harm. The first 2 categories, board of management oversight and compliance program, are used to assess a licensee's compliance management system, or CMS. As such, we will evaluate the assessment factors within these 2 categories commensurate with the licensee's size, complexity, and risk profile. All licensees, regardless of size, should maintain an effective CMS. However, the sophistication and formality of the CMS will typically increase with the size, complexity, and risk profile of the licensee. Again, the rating system and framework is publicly available. We will only issue 1 overall rating, and the ratings aren't formulaic in nature. Again, I'll have one of us drop it in the chat so that you can reference it. So again, the scope of our examinations are going to vary, but overall, they're going to include previous reports of exam, if applicable. It's going to be a review of the annual reports that you file with our department. The board of management oversight component is going to include your change management processes, your risk management practices. Your compliance program is going to include things like your policies and procedures, your internal training, your audit and internal routines and controls, complaint and dispute process, again, third-party risk management. Again, while we haven't necessarily implemented an information technology portion of our examination yet, we do plan on using the CSBS Cybersecurity Baseline Work Program, which is publicly available information. And again, every exam that we conduct is going to include some level of transaction review. And again, our examinations may focus on a particular part of your business based on the qualifying factors that we previously mentioned. So the examination workflow. So we will reach out to you by email or phone to inform you that you've been scheduled for an examination approximately 60 days before our on-site date. And again, the purpose of the introductory call is to kind of schedule a kickoff meeting with pertinent stakeholders, including the examiner in charge, as well as our management who will be facilitating the examination. The kickoff meeting will provide you an opportunity to ask us questions, and we'll ask questions to get a better understanding of your business to help determine the scope of our examination. Following the meeting, we will provide you with instructions to get onboarded onto the state examination system, as we can't send you the information request until your company has been onboarded. The information request is going to be due 14 days prior to the on-site portion of the exam, and this allows us to begin reviewing material prior to coming on site to minimize disruption to your business. All examinations will be scheduled for 2 weeks on site at minimum, but can be concluded quicker depending on the individual circumstances at the exam. Once the on-site portion of the exam concludes, the EIC will begin preparing the report of examination and reviewing recommendations, findings, and/or violations of law with our internal management team. The EIC will then schedule an exit meeting with your executive management to review our findings And then the ROE will be transmitted to you through SES and you will be invoiced in NMLS. Again, I know I covered a lot, but we're going to go into greater detail for each kind of section. So the prior to onsite key dates are really the initial contacts going to be made 60 days before. The information request is going to be submitted to you no later than 45 days prior to the onsite portion of the exam. You're going to be provided approximately 30 days to respond to our information requests. Once we receive your responses, we're going to then send you a list of accounts that we would like to conduct sampling on. So during the introductory or kickoff call, the EIC will introduce themselves and the manager responsible for the examination. Again, that's a time for you to ask questions of us as well as us ask questions about your business. All of our examinations, for those that aren't familiar, are going to be conducted through the state examination system. Again, SES is a secure system to exchange information and respond to our requests for information, and the ROE will be transmitted to you through SES. Again, at this time during the kickoff meeting, you will be provided the direct number of the EIC, and you're encouraged to reach out to them with any questions that you might have. If you need clarity on a specific request, please reach out to them. So the information request is sent. So again, approximately 45 days prior to the on-site date of the exam, our IR is going to be sent through SES and due 2 weeks before the on-site date, unless otherwise specified in SES. So some of the questions we've received are, what if I need more time to produce a specific document? Again, you're encouraged to reach out to the EIC and let them know specifically what documents you need additional time to produce and include information as to why you need additional time. Again, our information request is kind of comprehensive. So we have received questions as, what if a question is not applicable to the nature of my business? That's reasonable. So if you have specific questions not applicable, you can respond with not applicable, but please include a reason as to why that specific question does not apply to your company. So once we receive the responses from your company, the EIC is going to review the responses to ensure that they capture the intent of the request made. At this time, the EIC may send the responses back to your company for clarification or to provide additional support for your response. Once we're satisfied with your responses, we're going to be reviewing some of your documentation to produce a sample of accounts that we would like to review once we are on site, which we refer to as transaction testing. This could include things like call recordings, notes, payment histories, the initial placement record, correspondence, etc. So the on-site portion, the EIC's primary function is to coordinate meetings between your staff and our staff to ensure that over specific functional areas. The EIC is going to provide an agenda so that you can include pertinent staff related over that functional area in that meeting. EICs are instructed to keep your management team aware of relevant findings or violations of law while they're on site to provide you time to produce additional information before we conclude our review. So during the wrap-up phase, the EIC will begin drafting the report of examination and review their conclusions, findings, recommendations, and/or violations of law with our own internal management, and our management will ensure that they're well supported. So the exit meeting. The EIC will schedule a formal exit meeting with executive management if not conducted during the on-site portion of the examination. So management will be provided the opportunity to formally comment on the recommendations, findings, and/or violations, and your responses will be included in the report of exam. As previously mentioned, the report is reviewed internally before going out to your company. At this stage in the exam process, your management team should be well aware of any findings that we're going to be citing. So the ROE and invoice. So the Debt Collection Licensing Act, the Financial Code 100,023F, states in short that the report of examination is the property of the commissioner and shall not be disclosed to anyone other than the licensee without express permission. So depending on the severity of our findings, we will determine if a response to the ROE is required. The examination expenses will then be billed in NMLS and it will be due within 30 days after being invoiced. So the time frame between when we make initial contact to when the invoice is due in NMLS is probably going to be close to about 90 days, if not longer. So post on-site key dates. So on-site portion is going to end. The exit meeting is going to be scheduled about 14 days, within 14 days after the on-site portion ends. The ROE is going to be transmitted to you through SCS after the exit meeting within a 15 to 30-day period after the on-site portion ends. And then the due date for the invoice and the response, if applicable, is going to be 30 days after the report is transmitted and the invoice is placed in NMLS. So lessons learned. Again, we've completed several examinations at this point, and all the problems we've experienced have fundamentally been a result of a breakdown in communication. So if you're selected for an examination, we encourage you to ask questions. You'll be given the direct phone number of the EIC as your primary point of contact throughout the process. If we make initial contact, but your company ceases contact, we're forced to escalate internally, and this may lead to the revocation of your license. So our information requests. So we will request documentation to review to ensure compliance with any laws under the commissioner's jurisdiction. Refusal to provide information, delaying information, redacting information, or omitting information will increase the number of billable hours it takes to complete the examination, directly impacting the cost to your company. It can also lead to additional actions. At this point, that concludes my presentation. I'm happy to open it up to any questions that the advisory committee might have or anything that's in the chat.
I want to jump in real quick and say the last committee member has now joined us. And so Angela Reed Becker has joined us, and she's from Denali Capital. Is she still on? I don't see her picture anymore, but yes, I believe she's still on.
Oh, there she is.
Okay, so do any of the committee members have questions regarding the examination process? Oh, come on. Go ahead, Cindy.
Well, you know I have
I
questions.
know. We count on you.
So this is just a lot of information to digest, first of all. But I do have some key questions. The scale and the scope of the examination process is a little overwhelming. The time frame is overwhelming. I'm just going to cut to the chase. How much is this going to cost? This isn't a licensee. I mean, you're talking about being in our office and, 90 days to, examine all of this, information. You've already started some of this process with other licensees. What does it cost?
So for the cost, one, we can't disclose any costs that we've had so far because we can't disclose that information. That's confidential part of the actual exam. The cost of it is completely dependent on how much time it takes and also the degree of travel, because travel is a reversible cost. So as far as how we calculate it, any travel expenses is based on the current reversible costs examiners have per their contract with the state. Most of that is public information. A lot of it is actually based on federal per diem rates if you're out of state, and then the state has specific rates. So there are limits on hotels, types of airfare, set per diems for food, all of those things. So we do have a structure and limitations on what can be charged for travel. For time, DFPI charges $120 per hour. We work hard to be as efficient as possible. And examiners are required to track all of their time during the examination process. So that means if they're in your facility and they're working on your exam, but yet maybe they have to file their timesheet because it's the end of the month, they will subtract out that time. So when you're looking at, we'll give you our time, it's never, you're never going to see that it's the full 40-hour week. One of the things by having us ask for the information to come before we actually go on site, part of that is so we are limiting the amount of time that we're actually at your location. So as Herb said, we schedule for 2 weeks, but if we can get done in a week, we are going to get done in a week. So we do our best to get done as quickly as possible. A lot of that has to do with turnaround time, with the licensee and how quickly they can get things back to us is how quickly we can get back out of your space. I do also want to say to you that Herb kept saying, please call us and ask questions. You are not going to get charged for every call you make to us to ask a question. So let's just, I want to put that out there because we do highly, especially before the exam, we do really want you to communicate with us so that we can clear up as many issues before we are working full-time on the exam.
Okay,
I would
so
clarify real quick, the period of time when we make the initial call till when we submit the information request to you and we're waiting for a company to respond, we're not billing time waiting for you to provide us information. We'll only really start billing time when we get the information from the company to begin reviewing that information. So while the overall period might be a 90-day period, there's a finite period of time within there that we're going to be reviewing documentation, which would be considered billable work.
Okay, so follow-up questions, because I have several. One auditor, one examiner assigned to an agency, is it based on scale and scope?
It's based on scale and scope. Initially, you might see multiple examiners. That doesn't mean all of their time is going to be charged. So we currently are, because we're starting up this process, we have managers that are attending a lot of the exams. Their time is only charged if they're actually doing a project or doing something, once again, with the actual exam. And it is totally based on scale and scope, as how many people we have assigned. And can I get?
Yeah,
Yes.
absolutely.
Callie, would you like to ask your question too?
Thank you. What about for companies that are largely remote? So for us, we locations, but we don't keep any of this documentation on site.
That's part of what we need to discuss before the exam. So what we can access, what is actually there, how we can access information. Our ability to do things remotely has a lot to do with the company's ability to share that information with us remotely.
Thank you.
I'm going to only add two because there's a question in the comments. So we're billed while you're reviewing documents and while on site yet. So I want to address the ability for us to review documents before we come on site limits the amount of time that we're going to be at your location. It also allows us to, while we're on site, ask questions day one when we get there to get a better understanding based on the documentation that we reviewed. So it's really trying to minimize the impact to your business by not being on site for a longer period of time. So I would kind of conceptually view it as kind of a hybrid model where we're doing review offsite as well as on site.
Desiree?
Yeah, are you able to share any broad examples of things that were inappropriately redacted or learned from any past mistakes, or share some more more specific examples that are not so specific that it gives away any kind of confidentiality?
No. No.
Well, what I talked about.
But I will just reiterate, what we, our legal right of what, the department can look at is very, very broad.
Okay.
So be aware of that before you start redacting things or cutting things out.
Again, there's also the ability, like, again, the exams are billable. If you give us a 1,000-page PDF that isn't searchable and tell us, oh, it's what you're looking for is in this 1,000-page PDF, it's going to take time for us to search it, and you're going to be billed for that time. So if you can ensure that the documentation you're providing us is in a easily digestible format or point us in the right direction, it ends up saving you money in the long run on the invoice.
And that gets down to the communication we were talking about. If to help, the more we communicate, usually the faster things get done. And Scott?
Yeah, hi, thanks. I think following up on that same line of question, for law firm licensees, debt collection law firms that have been issued a DCL by the department, how is the department handling, or how has it handled in a very sort of broad context, the attorney-client privilege and the attorney work product doctrine for those law firms?
We have not examined a law firm yet.
Okay.
So I will tell you, we have not tackled that challenge yet. We do understand and respect the attorney client privilege. And Colleen, would you like to add anything to that, or?
Yeah, I believe our legal division would coordinate with our program to ensure we are not imposing on the attorney's ethics or professional responsibilities when we are examining debt collection activities.
Yeah, it's not our goal to make someone break the law. Okay, so I don't think we need to worry about that. This is part of the challenge. As folks are aware, the Debt Collection Licensing Act covers multiple industry segments with different business models, different sizes, and different levels of complexity. So it's tough to give a one-size-fits-all answer about, is the examination going to be like this or like that, because you all got different businesses. So it's a fact-specific inquiry, but I think the takeaway is communication, communication, communication. Supervision, it's confidential. Right? So the more that we're sharing information early and often, the more we can be efficient. Again, to level set, this team is about 30 people, and we've got more than 1,200 licensees. So, we don't have a ton of time and a ton of people to be up in your business for an indefinite amount of time. That is not our goal. That is not our purpose, but we are statutorily required to, to bill for our time so we can pay for the cost of running the program per the statute. So this really is meant to be, an effort that is, we're here to be transparent, open, and honest, and make it as efficient as possible so that we can discharge our duties and then you can get back to your business. So really welcome the additional feedback and questions.
Thanks, Suzanne. I just to start. So, I mean, implicit in, I think, what everyone said is that the department isn't saying that attorney licensees have waived the privilege or work product doctrine simply because they have become licensees. That the department's still going to honor those privileges. But then unrelated to that question, if I could just follow up, what's the typical length of a duration of a typical exam? I know it varies by size and scope, but you've done some. So are they done in days? Is it weeks? Is it months?
Again,
weeks.
Yeah, we're going to be scheduling every exam for 2 weeks on site.
Perfect. Thanks.
Ideally, we're trying to be as efficient with our time as possible by reviewing some of the documentation before we go on site so that we can minimize our time there.
Terrific. Thank you.
Yeah, so I guess just a 30,000-foot level, if you are accepting the documentation over, your secure portal, your SES, and the statute does not require currently for in-person examinations, why the 2 weeks? If we provide everything to the department for you to review, what exactly are we doing on site then for a 2-week period of time that is already being provided to you electronically?
I think that question's twofold. Are you questioning why we come on site, or are you questioning about the duration of the on-site portion of an exam?
I think I'm more questioning the on-site. Why are we doing that? If we're obtaining and providing, because most of the examinations in the other states, they are done remotely. And we submit that information. So if you have 30 examiners and 1,200 licensees, if you have the ability to, review that information, be it in advance, come back to the, licensee with additional follow-up questions, which we're happy to provide to you. I'm just trying to understand why we need to come on site, because it's overly burdensome for a business, that works on a calendar month to provide services for their clients. They may or may not have staff available to sit down and meet with somebody on site for a 2-week or extended period of time. However, they could probably source, if it's done, a request is done remotely for additional items.
So again, the problem I have with that comment is that they don't have the ability to sit down with us when they're on site. What's going to give them the ability to actually have a virtual call with us when we're conducting an exam?
Well, a phone call is different. In the day-to-day, obviously we can set some time aside. But if you're physically in the office for 8 hours in a day, is it the expectation of the department that, we, as a licensee, have a dedicated person sitting in the room with you?
No.
No.
No, we do find that if we are there, it frequently goes quicker for our transaction testing. Because one, you can't always give us remote access to your systems. So we need to look at files. We need to look when we're doing transaction testing, which is why, Herb had mentioned that we send our transaction testing list to you beforehand. So a lot of what we're doing on site is looking at the actual transaction and transactions and payments and those items. The policy review, things along that line, yes, we do those offsite. So we do that before we go in, then we go in. And then the 2-week is not a set in stone amount of time. It can be 1 week, it might be 2 weeks. We do not want to say 1 week and then get in there and say, now we're going to be in there 2 weeks. It's much easier for us to say, okay, we're going to be there 2 weeks, but leave as soon as we're finished, whether that's day 3 or day 9, that we would then leave once we have, because at this point, we don't have enough examinations completed to guarantee, to really give you a high level of this is how long it's going to take. I can say from my previous experience doing other industries, it usually takes a minimum of a week, but frequently 2 weeks. And it will depend on the size of the company. We will adjust our time based on the size of the company. And one thing that we try to do is we set a time. And instead of having the exam linger on for weeks or months, we have a time frame. We go in there, we look at what our scope is, we complete it, and then you get feedback within 30 days after we're done. So it is a more concise, consolidated exam than what maybe you're used to with some of the other states that do them.
Well, this is way more extensive than most of the states that I have experienced, to be quite fair. I think the documentation list, and I think that's honestly kind of the benefit of having this committee as well. I've been serving on this committee for 4 years, and I somewhat thought that we were going to be interactive in helping you develop some of this process before you began, the examinations. I hope that as this is my final year serving on this committee, that moving forward, that the, advisory committee, who are the industry experts, have an opportunity to be able to provide feedback proactively to the department to help you develop, your processes for licensees, because we want to streamline, what you're looking for as well. And that open line of communication is why we're here. So,
Again, I want to,
Hello, we have another question, Angela?
Yeah, I mean, to Sydney's point, I mean, being on site for 2 weeks is very, very extensive audit period. And if we're looking at transactional type activity during the on-site process, or even answering questions for policy related, there really isn't a reason why you couldn't do a Zoom call, share screen, and go through the transactional pieces and be able to meet the documentation requirement. I mean, 2 weeks is very extensive. I don't think I've ever seen a state audit go for a 2-week period or even a week period at a transactional level. So I guess, have you received any feedback from your licensees about that time period or the constraints that it puts on the business, positive or negative?
I want to add regarding the feedback, we do have a process where we're going to kind of establish a feedback loop with our licensees by sending them kind of a post-exam survey at the conclusion, looking for feedback on our overall process, things that we could improve upon, areas that they liked, interactions with our examiners, so that we could kind of internally develop the program based off of our licensees' feedback. So we are going to implement kind of a post-exam survey. Regarding the time, and I don't think something that was considered, is we do like to sit down with collectors and do collector interviews. It's hard for us to do that process if we're not physically on site, listen to their interactions with consumers, how they manage their process, ask them questions regarding the training that they've conducted. Again, if you hire a new collector, we might want to sit down and see the training that you provide that collector. That's not conducive to a virtual environment. So there is value to the on-site portion. Again, the only thing that I can emphasize is that we take great level of consideration in minimizing the amount of time that we're going to be at your institution. Again, I know it's painful. I understand that. We want to try to minimize the amount of time that we're there while completing the necessary work that we've been charged with.
Great. I know you have a small sample size just because it's still February right now. It's February, right? Yeah. But are you able to say what percentage of those that you've examined have complied to a model examinee? Like, have you had a model examinee yet in terms of complying with the paperwork and the timeline and all of that? Have you had anyone yet?
I would say yes, we have. So
Yes.
yeah.
And in that situation, were those less than 2 weeks in the office?
On site,
Yes.
we anticipate, yeah. If in a
Okay.
perfect world,
So
if
they're
you're
not
complying with our request for information, we anticipate being able to conduct our review in less than 2 weeks. However, we want to make sure part of the reason for scheduling it for 2 weeks is we want to make sure that the schedule for your executive management is clear to address questions while we're on site. If your compliance manager is on vacation during the on-site portion of the exam, that's not conducive to us being able to complete our review. If you don't have a compliance manager, we're probably going to be talking to whoever's in charge of the compliance function. So again, we're trying to clear schedules for both the exam and your time so that we could complete our review.
And this is part of the communication once we call you, is to determine, while we're there, are there certain days that we cannot have meetings because of conflicts on management schedule? So a lot of this gets worked out in that 60-day period before we actually go on site. Okay.
Yep.
Um,
I was gonna say, Desiree, we've had good examples and we've had bad examples. So the bad examples end up taking longer periods of time for us to get our job done.
Yeah, I'm just curious to know that in like a model example, how, you know, what in a perfect world, what is that timeline looking like? And it sounds like 2 weeks is the outer limit in like a best case scenario, sorry, in a worst case scenario.
on
Yeah, I
an
would say 2
average
weeks.
size institution.
Yeah,
Yeah.
2 weeks is the median. So again, if there's again, you're gonna hear the term size, complexity, risk profile, because that's kind of how we try to capture and define our licensees. So if you're a large debt collector, we might be there longer. We probably will be there longer than 2 weeks based on the scope of our exam. If you're a small debt collector, we're going to be on the shorter side of the 2 weeks. So again, median is that 2 week period, is the 2 week period.
With a larger debt collector, would you assign still just one examiner, or would there be two potentially?
So our exam team is, there's always going to be an EIC. So the EIC stands for examiner in charge on some of the multi-state examinations. So if you're selected for a multi-state exam, there's going to be another role called the SPOT, which is the single point of contact. So they kind of help backfill the EIC role. There's also going to be team members on each exam. So if you're a small licensee, it might be one EIC and one examiner. If you're a large institution, there's going to be an EIC, potentially a SPOC, and probably 1, 2, or even 3 examiners assigned to that exam. Again, the more examiners we assign, ideally, the quicker we can complete the exam. Cindy?
How do you determine what's large versus what's small? Is it FTE?
It depends on the nature of the business, right? So again, we license such broad companies in different industries that we have a difficult time determining what is truly. So if you're a third-party debt collector, and that's all you do is third-party debt collection, then yeah, maybe FTEs would be appropriate way to determine the amount of collection activity that you're conducting. Now, again, if you're a finance company, that might not be the appropriate tool. If you're a law office, that might not be the appropriate tool. So again, part of it would be looking at your annual reports that you file to determine, again, if there's a change over time in the amount of volume that you're transacting, that would give us some sort of insight as to the amount of collection activity that you do. Again, it's not going to be just complaint driven.
And where there's an opportunity to leverage multi-state, right? I mean, that's why we have the state examination system. You know, we're trying to make it so that, you know, you don't have different people knocking on your door, you know, all at once. I mean, we're trying to do wherever we can, leverage collective resources, you know, across state regulators to make sure that, you know, we're not duplicating efforts and that we're using our resources efficiently because they are limited.
And the use of the SCS system, that does allow us to bring in more states and for us to work more cooperatively with the other states. It also allows, because the request, the list of items that we request is very extensive, but it will save those answers. So the next time we go in, we can see, oh, they said NA for all of these things. They don't do that. You know, we can just push that aside, or, you know, it does allow us to keep fine tuning our processes.
You know,
We'll let you ponder a moment and we'll have our next, and then
we got another.
oh, we have another. I was gonna say, okay.
All right, I was just wondering, what would cause a multi-state examination? I'm not familiar with that. I've never heard of that.
It's again, a multi-state examination would be where there's a debt collector that's licensed in multiple states, and we would have a working relationship with the other state agency. If they have just gone in and done a debt collection exam, we might request a report of exam and see if the company is a target or worth going in and completing our own exam. If they haven't done it, we'd have a conversation like, hey, is this person on your radar? When was the last time you completed an exam? Would you want to participate in a joint exam? And that really, from our standpoint, it frees up additional resources to complete more examinations. So rather than having 2 or 3 of our examiners, it might just be one of our examiner and one of their examiners going in and writing a joint report of exam. So again, each state would look at their own individual laws that they have to ensure compliance with, or from, let's say, a CMS standpoint, CMS is applicable to both states.
And I'll also add to that, on some of our multi-state exams, not every state's going to go in there in person then. They'll send a part of the team in person and the other part of the team will be off-site. So they'll split the assignments that way. So once again, we're not trying to reduce the burden if we can.
Will the PowerPoint presentation be available to the committee members?
I don't have any issue with that, Melinda. Suzanne.
Yeah, Sunday,
Recorded
if
here,
you
we
could
can
send
send
that
it.
out.
Yep. Are we moving on to another topic? Because I did have a question
No, we
with
can-
regards to, I think, part of his original beginning part, and that was actually regarding the assessment.
Sure.
Because it was part of his
Yeah.
initial.
Well, yeah.
So on the assessment, you said, because the annual report's due this year and the assessment is coming up. And I know that this committee has done some work to provide feedback regarding how the assessment is calculated, this pro rata portion that's indicated in the statute. Can you speak at all to, any feedback? What does that look like? Has the determination been made yet for the pro rata portion based on the annual report and how that assessment is going to be calculated?
The calculation,
Looking at the data.
so it's based on the net proceeds. Everyone submits their net proceeds. That's happening right now.
Mhm.
Those reports are due in a few weeks. We then take all of those and it comes out to I was going to say basic math. I mean, you just add them up and each percentage of the total net proceeds then gets multiplied by the sort of next fiscal year. So it'd be our 25-26 fiscal year budget, and that's the portion you pay is based on that. And if there are companies we have a minimum, but the minimum's only $250. So it will range completely from 250 up to whatever percentage our largest company has. So what we are doing now is we are contacting anyone who turns in their report. We are contacting people that have what we think are out of the norms for high or low. So if we do contact you, please, be aware. That's why we're contacting you. And it could be that you're extremely high and that we feel that there's some sort of error in what was inputted, or that if you're, low based on some of the other numbers that you've inputted, we're also going to ask you, why are you reporting 0 if you said you collected all this? It's going to go both ways. So we are trying to contact everyone that is outside our average numbers to verify, because this is our first assessment and we want to make sure we're working with accurate numbers.
Okay, so just to clarify again, because it's very complex the way that it works, because the DFPI in general has an operating budget. So this is the allocated portion only to the DCLA
Yep.
and its licensees. So it's
Yes.
now the overall budget of the DCLA and its people within the DFPI overall umbrella, or is it like gap filling the shortfall that is not obtained or allocated by the annual budget by the state?
It is simply the DCLA's budget. Our budget. It does not include any shortfall the state might have or anything. It is, we try to work on a zero income level. So based on what our budget is, we allocate for that budget. And the goal is at the end, we have no surplus and no deficiencies.
That's the way our entire department is set up. We are a special fund department. We are not outside of the special grant program pot of money. We are not a general funded agency. Our licensees across licensing programs of the department pay for the cost of their regulation. And so that is the way that we ensure that we can administer our statutory mandates. And so it's the same in this program as it is in other licensing programs. Yeah.
I get that. That helps. Thank you.
At this point, again, I appreciate all the questions on examinations. If there are any follow-up questions, I encourage you to reach out to our inquiry inbox, just kind of flag in the subject line examinations, and I'll respond to any additional questions. And we'll make sure we get that PowerPoint out to everybody. At this time, I'm going to turn it over to Charlie.
Hi, everyone. I'm just going to provide a brief update on the DCLA scope regulations. The department is in the process of finalizing a revised draft based upon the feedback we've received thus far. We anticipate publishing a revised draft for comment within the next 60 days. And then once we have feedback on that we've incorporated, we would initiate formal rulemaking. That's all I have on the rulemaking. Unfortunately, Emily, who's the person with the pen, is out sick today.
Did any of the committee members have a question about what's going on rulemaking?
Are all the rules finalized that are currently published right now?
No, the scope rulemaking is, we're still in drafting stage, and the annual report rulemaking, it should be finalized in the day, any day now.
We're waiting on the Office of Administrative Law for that one. So yeah, but it's with them.
Okay, well, we're now at our roundtable period, so happy to discuss any topic that the committee members would like to bring up. We can continue with just if you have more questions about either the assessment or the examinations, or if there's any other topics the committee members would like to bring up. We'd like to hear from you.
Melinda, I guess I'll ask a question, which is perhaps the question that I ask in every one of our, of our meetings, but the commissioner reported that she was in discussions with the Supreme Court or the Judicial Commission about overlap between state bar licensing and DCLA licensing. Is there any update on that?
I can provide a brief update on that. So I believe on the last call, the commissioner indicated that she wanted her staff to connect with the state bar to discuss the question of attorney licensure. We've completed those discussions with the state bar, and we've we're making decisions based upon that discussion and other or those discussions and other considerations. But we've already we did follow through on what the commissioner indicated we would do during the last meeting.
Do you think that we might see the results of those decisions in the scope regulations, or?
I can't speak to the specific language until it's released.
Sure.
So I just don't feel comfortable speculating on that right now.
And also, and to state the obvious, we have a new commissioner, so we need to,
I know.
leadership, we need to, brief the new commissioner, get him up to speed. I mean, he was our chief deputy, but has not been as closely involved in monitoring this particular rulemaking. So it's important for us to do our internal due diligence there as well. So.
Thanks, Suzanne.
Are there any other, does anyone else like to make a comment from the committee before we open it up?
I mean, I'm not sure how many of the committee members are going to be serving or have applied to serve for another term. Just on behalf of myself, I just want to say thank you to the department for the last 4 years. I'm not going away. I'll probably come in, attend in person if I have an opportunity to. But it is definitely time to pass that torch to others in industry to participate in this committee. And hopefully, again, like I said, proactively give feedback to the department to help, use us as an active resource to better understand how agencies operate, the benefit that our industry serves to the business community. And from a global scale, I mean, we want to work with you. That's why we're here sitting at this table. So we just ask moving forward that you proactively involve us in, getting our feedback before, rulemaking or through the rulemaking process or examinations, not because we're being examined, but because we're a resource to the department. And I don't know if anybody else wants to share their experience over the past 2 years. I think that would be beneficial, I think, for the department to hear.
Yeah, I mean, this is a terrific, it's terrific that the department has set this up to provide an opportunity to receive input from industry, to allow the general public to participate in these meetings, and to use these meetings and members of the committee as conduits to their respective constituencies on the things that the department's doing. So you should all be commended on your hard work.
Robert, you're muted. You're still muted.
can't hear
Still
ya.
muted. Can you unmute him manually, maybe, on Sunday? Wait, here we go. Oh, we just can't hear him.
Is your volume down maybe? Because we heard you earlier this morning. It's weird.
Oh, wait, I got something.
You got it?
Barely.
Yeah, you're faint. We can get a little
Well,
audio.
I'll speak loud, and that's probably a good thing. I'm faint. How's that?
Okay.
All right. I'm not sure what the reason for it is, but as long as you can hear me, number one, I've respected and appreciated the last 2 years of being on the committee and learning a lot. I've kind of considered it a learning curve. I've been in the business since about 1978. When the prior licensing organization was here, and probably I didn't think they did enough in some ways, because they would have an examiner come out and they would examine your books, and you send in your every 6-month reports and all that, and it worked fine, but they would never do anything about the bad actors. So to the level that you guys are involved, I think I get the impression, at least, that you will deal with the bad actors. When we brought a bad actor to the attention of the Bureau years ago, they would say there's nothing they can do because they're not licensed. And I thought that was a little ironic. So to see you guys being involved in this, I'm assuming, and I can only assume, that you guys are taking a proactive role with your agencies, due to the fact that, number one, there's a learning curve for you, but also there's a sense of, I guess, for the agencies, an unsure feeling, especially when we come out with these requirements for examinations and such, based on what was and what is now. My only comment would be that, I mean, I'm a tiny agency, probably because we restarted several years ago, but I would see a day maybe looking at my data, but you may have other things I learned from that as well. So I guess this has been a very constructive group. I appreciate the fact that I've been able to serve on it. I hope I did apply for a second term. And I hope that, you know, as the cohesiveness of the group comes and it becomes more routine and standard, I think everybody will start to flow with you, I guess is my point. So I don't think there's, you know, like I said, if I fear more of the bureau that, or the licensing board that didn't do anything than somebody who does and tells exactly what you're going to do. I appreciate that. So I look forward to continuing to keep informed and involved. So thank you.
Thank you for that feedback. And also a reminder to the group that unlike some of our other older licensing laws where there may be like a very set statutory exam schedule, under the DCLA, it's risk-based, right? So lower the risk, less likely we're knocking on your door, right? So that gives us the flexibility to make sure that we're allocating our resources where there really is a true risk to consumers and the public. And so that speaks to your point about how, you know, we're not just indiscriminately and unstrategically knocking on everyone's door. We want to go where we're needed, right?
I would also add that, you know, in the examination process, there may be things that your examiners aren't used to in our industry, and they should be able to reach out maybe to some of the committee members if they have questions as well. I don't know if you could hear that, but
sure,
that might be of assistance to you guys.
Okay, if we have no more comments from the committee, we still have time if there's any more comments, but otherwise we will move to our 10 minutes of public comment. So during the public comment period on Zoom, to make a comment or ask a question, please use the raise hand function. You can also use the chat function to make any comments or ask questions. If you have dialed in, you can press #2 to raise your hand and to call for comment, and you'll be prompted at the time for you to speak. We will get to as many questions as possible. If we are unable to get to questions or cannot answer your question immediately, we will get back to you. So we do look at all the comments in the chat at the end of the meeting too, to make sure that we've addressed them, and we'll get back to you if need be. So is there anyone in the in the public that would like to make a comment? If you're online, please raise your hand. Okay. We'll give it a second, but. Okay, so not seeing any additional comments, we can go ahead and close our meeting. So I thank you all for participating. The next advisory committee meeting will be in May or possibly June, where we will hear from our new committee members. So thank you for our current committee members. I have enjoyed working with you.
Thank you, everyone.
Thank you.
Thank you. It's been nice working with everyone.
Bye-bye.